Good afternoon. I want to call the Criminal Justice Committee to order for April 7th, 2021. Madam Clerk, please call the roll.
Representatives Beck, Campbell, Dixie, Doggett, Farmer, Griffey, Hardaway, Hawk, Howell, Holsey, Lamar, Lambert, Moody, Russell, Sherrill, Vice Chairman Sexton, Chairman Curcio. Chairman, you have a quorum.
Thank you, Madam Clerk. Members, before we get started today, do we have any personal orders? Seeing none. Members, today, as you know, we have a special task before us before we get to our regular calendar. So if you're here, members of the public, to hear some bills that will be discussed later, you do have a little bit of time because we have our first order of business is a hearing on the confirmation of Judge Jill Ayers. So we're gonna bring that up first. And I want to give a little bit of background, first of all, for full disclosure, and I'm honored to be able to sit here today because Judge Ayers and I have been friends for a number of years, and I think the world of her. And when I heard that her name was being considered for this role, I was very glad to hear it. So glad to have her here with us today, and I think members, Judge Ayers has been around to several of the offices to hopefully meet with some of you, and if you haven't had a chance to speak with her, would encourage you to ask some questions today or maybe try to catch her afterwards and just get to know her a little bit. She's a fantastic person. So just to remind everybody, a constitutional amendment was proposing the judicial confirmation process was approved by the voters of the state on November the 4th, 2014. So that's why we're here today. The procedures governing the process were passed into law by the General Assembly on January the 28th, 2016. And when a vacancy occurs, the governor appoints a nominee to fill the vacancy subject to a vote of both chambers of the General Assembly. The role of the Criminal Justice Committee of the House of Representatives and the Judiciary Committee of the Senate is to hold a hearing on the nominee and to provide a recommendation either for confirmation of the nominee or rejection of the nominee to their respective bodies. So the way we'll get started this morning is the governor's chief counsel will introduce the nominee to the committee. The nominee will make her opening statement, and then I will open the floor to questions from members. And then following those questions, once the committee has asked everything they need to ask, then I will entertain a motion either for a recommendation for confirmation or a recommendation for rejection of the nominee. I will then gavel us out of session and ask the governor's chief counsel and the nominee to come forward. So I'm going to do that now. So if anybody, unless anybody has any questions about the process. All right, seeing none, we will go out of session. Mr. Wiseman, you're here today. If you could please introduce us to the governor's nominee, sir.
Thank you. My name is Lane Wiseman, and I have the privilege of serving as Deputy and Chief Counsel to the Governor. And it is my distinct privilege to introduce to you today Judge Jill Ayers, who currently serves as a Circuit Court Judge in Montgomery and Robertson counties. As you know, this process begins with an opening on the appellate bench. The Governor's Judicial Council meets and considers applications. There were 11 applications that were considered. That council then sends 3 names to the Governor for consideration. Judge Ayers was a phenomenal candidate, and I want to tell you a little bit about her background before we get started here today. Judge Ayers grew up on a farm in Todd County, Kentucky, and she moved to Nashville to attend Belmont, where she earned a degree in English. She then studied law at the University of Tennessee and graduated in 1992. She returned back home to Clarksville, where she practiced for 23 years at the firm of Batson & Nolan and was appointed to the bench by Governor Haslam in 2015. And she has since run and won a contested election to that same position. She presides over criminal court in the 19th Judicial District and has presided over 50 jury trials. Her appellate record in our research is spectacular. She recently completed a term as the presiding judge of the 19th Judicial District during the pandemic, which has obviously presented significant challenges balancing the issues with COVID-19 with the constitutional rights of criminal defendants to have their day in court. And she's done that with success. She's active in the Tennessee Judicial Conference, serves on the executive committee of the Tennessee Trial Judges Association. She's a current member of the Tennessee Judicial Ethics Committee, and the TBA, and Montgomery and Robertson County Bar Associations. She's also active in many different community organizations, including Rotary, the Clarksville Sunrise Rotary, Montgomery County Republican Party, and Montgomery County Republican Women, as well as being a Tennessee Promise mentor. Judge Ayers is married and has 4 sons. She's here today with her husband, who notably is the associate head men's basketball coach at Belmont University, who has had quite a successful run over the years. And I'm here today to commend you to her on behalf of the governor. Court of Criminal Appeals tends to attract the best and the brightest, the appellate court vacancies, and this is no different. As I mentioned, there were 3 applicants that were sent to the governor for consideration. As part of that process, we we perform background checks, research their record, and interview the candidates. The governor takes this responsibility very seriously. He is heavily involved personally in the process, and I can tell you that there were 3 very good applicants, but Judge Jill Ayers certainly stood out among those applicants. We interviewed her, asked her lots of questions, delved into judicial philosophy, thoughts about the roles, the appropriate role of judges, and I can assure you that she possesses the intellect, the understanding, and the philosophy that certainly is aligned with the governor's view, and certainly I think would align with the views of this committee as well. There's a host of reasons why the governor selected her, ranging from her professional reputation and standing and the level of support she received in the community. I think it's notable that throughout this entire process, we did not receive one negative word about Judge Jill Ayers. And that's amazing if you stop and think about it. You preside over criminal court. There's a lot of winners and losers when it comes to that sort of job, and we didn't receive a single word either from the bar or from those in her community. I think that she is uniquely able to articulate the type of judicial philosophy and worldview that's important to the governor and to all of us who believe that judges have an appropriate role to interpret the law, not make the law, and that the actual text of the Constitution and statutes should be and are the most paramount concern of the courts. And I think you will find in your questioning that you will find that she is uniquely suited to that worldview and uniquely able to articulate it. And with that, I would commend you commend her to you for your consideration. Now, before I go, I'd be remiss, and I want to set the stage that due to certain ethical restrictions based on the fact that she's a sitting judge and a prospective Court of Criminal Appeals judge, it would be inappropriate for her ethically to discuss specific cases or specific issues. And so while she might want to answer all of the questions that you ask, she may not be able to for ethical reasons, although certainly her judicial philosophy and worldview are open game for questions, and I would encourage you to ask her. But certainly we would not want her to violate her ethical duties, but also potentially to be forced to recuse herself on an important case that we would all want her to be able to hear in the event that came about. So with that, I'm willing to answer questions. I know that you certainly did not come here today to hear from me, but I want to hear from the nominee. But certainly I'm available if anyone has any questions of me about the process or about the applicant.
Members, any questions for Mr. Wiseman? Okay, thank you, sir. We appreciate you.
Thank you.
Ma'am, if you could please come forward. And while we have said your name several times, this may seem silly, but if you could please state your name for the record, and we would invite you to give your opening statement.
Thank you, and good afternoon. I am Jill Barty-Ayers, and as mentioned, I'm currently Circuit Court Judge for the 19th Judicial District, which covers Robertson and Montgomery counties. It's a pleasure to be here today. I want to thank Mr. Wiseman for his nice comments and introduction. I want to thank my representative, Curtis Johnson, for being here today and being so supportive throughout this process. I also want to thank Governor Lee for his confidence in me and appointing me to this position. As mentioned, there's a vacancy on the Court of Criminal Appeals in the Middle District that was created by the retirement of Judge Thomas Woodall from Chairman Curcio's district, and I thank Judge Woodall for his many years of service to the bench as well. My husband is here today, as Mr. Wiseman introduced, Brian Ayers, and he's been incredibly supportive throughout this process. Unfortunately, none of our boys were able to be here. We've got 2 in Chattanooga, 1 in Knoxville, and 1 here, and 2 of them are trying to, or they tell us at least, that they're spending a lot of time studying to graduate in May. So to be continued, we'll let you know how that goes. But I do want to thank you all for your time. I know the last couple of years have been really challenging for you all and presented some unique circumstances for all of us to work through. So I appreciate you making time for me today as you consider my confirmation to this appointment to the Court of Criminal Appeals. As mentioned, I was appointed to my current position as Circuit Court Judge by Governor Haslam in 2015. So for the last 5.5 years, I've been presiding over primarily felony criminal cases. Prior to that, I did have a civil practice as a partner and member at Batson Nolan, which was a law firm having offices also in Clarksville and Springfield. So with that, I will look forward to answering your questions this afternoon. Thank you.
Thank you, ma'am. We appreciate that opening statement, and I can say time flies. Yeah, it's hard to believe you've been on the bench for 5.5 years, but I know all of us who had worked with you prior were pretty upset when you left private practice. So I can't believe we're actually considering a promotion today. But no, very, very excited to see this. Members, first on my list, I have Leader Lamberth. You're recognized.
Thank you, Mr. Chairman, and I have a question in a moment, but I also want to echo the chairman's comments. Judge, I've only been in your court a couple of times, but I've heard lots and lots of lawyers and members of your community brag on you on a regular basis on being fair and even with folks. And many of those folks I heard were leaving your courtroom and had lost in their case. So just as Mr. Wiseman said, all we can ever ask out of any judge is to be fair, to call balls and strikes, and to take the laws that we put in place and truly just apply them in your courtroom. And I've heard from a great number of members of your community that that's exactly what you do. In saying that, that leads into my question. In an age of judicial activism, we have seen a rise in the number of judges legislating from the bench. Do you see the role of a judge as one who reads between the lines to create new meaning in our laws, or as one who interprets the law based on a strict reading of the natural and ordinary meaning of the statutes we enact?
Well, certainly the latter. I think there's no place for judicial activism. I believe in the separation of powers. It's the judge's role to simply apply the law as given to us by the General Assembly and as written, as it says in the Constitution, and just apply the law to very unique circumstances and facts and controversies that come before us.
Leader Lambert.
Mr. Chairman, thank you, Your Honor. That absolutely was a perfect answer. I didn't tell you exactly what the question was going to be beforehand, but that's exactly what we would ask of you. And thank you for your service thus far, and I certainly support you stepping into this new role, and I'm confident you'll do a fantastic job. But thank you for being here today, and I look forward to everybody else's questions. Thank you, Mr. Chairman.
Thank you, sir. Next on my list, I have our Minority Caucus Chairman, Vincent Dixie. You recognize her.
Hi, thank you for coming. I don't really have a question, it's more of a statement. I have a long history with Batson Nolan. When I first started my business in Montgomery County in Springfield, Mr. Nolan matched me and a young attorney named Ben Dean together. I guess he figured neither one of us knew what they're doing, let them figure it out on their own. And we ended up we're great friends now, and he supported me, to do everything, and I've supported him in his business. And so I do have an affinity for Batson Nolan. And then, of course, can't get away from the Nolans here. You still have Bill Nolan follow me around. And I think you do a great job. I haven't had much time to deal with you in Montgomery County, which is a good thing because I've never been before you in court. So I think that's off to a great start already. I think Leader Lamberth's question was a very pretty much encompassed what we all want to know. Can you be unbiased and just do your job and not fall victim to the pressures that come along with your job? Because there is obviously in this atmosphere of environment of what we have going on today, there's a lot of outside influences that go on that pull you in each direction, and I think you've shown that you can handle those pressures. So I wish you good luck, and hopefully I'll never have to appear for you. So I want to keep that streak alive. But thank you again for coming here.
Thank you.
Thank you, Representative Dixie. Next on my list, I have Chairman Doggett. You recognize, sir.
Thank you, Mr. Chairman and Judge. Thank you for being willing to take on this role. I wanted to ask you, throughout your judicial career, have you perhaps, and if you can answer this or not, but what would you consider some of your greatest achievements in the judiciary? And then if there are any, maybe some of those that, some mistakes or failures or that you might have had and how you overcome those?
Thank you. I think as far as greatest achievements in this profession, in this role that I have, am currently in, would just be coming in. I came in kind of a tumultuous area where there had not been a criminal court judge on the bench for several months. So there was a significant backlog of cases, and also, as mentioned, having a civil law primarily background, I feel very proud of how I was able to learn and apply the law, as well as managing that backlog of cases. As Mr. Wiseman mentioned, I hit the ground running literally, I think, within about 3 weeks of my appointment, had my first week-long jury trial. That's one of the things I do enjoy about the criminal courtroom. You're in the courtroom a lot more. So I would consider that probably one of my greatest achievements in my current position. As far as any failure, we never like to admit failure, but we are all human and we all have areas in which we can improve. Just off the top of my head, I would think of one situation in a jury trial where we got all the way to the end of a homicide trial, and a juror had withheld some information that we found that out. He finally told someone that we should have known. It was hard to determine, I guess, how we could have brought that out sooner. But I think what I learned from that, so we had to declare a mistrial, which is always frustrating and one of the things that people don't want to do. It's the goal of everyone to get the trial finished, be fair, and get a good result. But in that case, I think I learned to ask more questions of jurors and to try better to make them more comfortable to understand if anything comes up at any time over the course of the trial, that they needed to bring that forward so we could address it.
Chairman Doggett?
Thank you very much. That's always perhaps the toughest question that people ever ask, and I always dread getting asked those questions because it's hard to be critical of yourself and especially things that you're passionate about. But it's those failures that once we recognize those, we grow from them, and it makes our successes that much better. So thank you so much for your answers.
Thank you.
Thank you, Chairman Doggett. Next on my list, I have Representative Hardaway. Representative Hardaway, you're recognized.
Good afternoon, ma'am. Thank you, Mr. Chair. Not sure if that look says my reputation precedes me or what. I hope not. You said earlier that you're not, when your judicial philosophy is not that of an activist, so you practice restraint, or are you moderate? Usually the three areas are defined as liberal, moderate, conservative. So do you fit in one of those, or do you have a different way of describing your judicial philosophy?
Well, I would just describe it as judicial restraint. Again, I think the judge has a critical but limited role. Again, we are there to apply the law as is given to us, and the law that the words that are in the Constitution, the law that comes to us from the legislative body. And our opinions, feelings, ideas about things, or anything about the outcome does not matter. So that is my philosophy.
And would that philosophy ensure that, though most of the research indicates that you do have a political preference, that would not influence your judicial decisions?
Politics or any other personal opinions of a judge have to always be set aside. So there's no place for those in the courtroom. There's no place for those in the judicial branch.
And what about gender? What will be the composition of the courts when you join?
Currently in the Middle District, I would be the only female there. As far as gender goes, there's a female Court of Criminal Appeals judge. If this goes well today and the confirmation goes through, then we'll have one female in each Grand Division.
And that's out of how many judges?
12.
And women make up about half of the state.
We have 3 of 5 at the Tennessee Supreme Court level.
Well, we're trying to get it right in one court. The only other thing that I would ask is that and there's some subjectivity to this, and some subjectivity to the way I do my job. I think anyone that does a job and not being honest, intellectually honest, if they don't say that their experiences in life influence how they interpret law, and whether it's a meaning that you're interpreting or how you're going to apply it. There's some sense of your personal experiences that are going to help you in how you understand things, whether it's law or baking or driving a car. So with that said, I'm going to ask that you be conscious and aware that your experiences may or may not reflect, and I'm not trying to preach to you, but just to give myself some assurances, that your experiences may or may not reflect those of the citizens who come before you. And we have quite a few who are not, in terms of socioeconomic status, are not going to be on your level. May not be on your level in terms of educational attainment. May not be on your level in terms of culture. Well, not on your level, but fit in terms of cultural awareness. So I'll merely ask that you keep that in mind, and I'll be watching you, as I'm sure you'll at times be watching me, saying, is that the guy that sent this old jacked up law over here? But thank you, and good luck with your appointment.
Thank you.
Thank you, Representative Hardaway. Next on my list, I have Chairman Hawk. You recognize, sir?
Thank you, Mr. Chair, and really just a bit of advice for you. I was honored to meet you earlier today, and as you mentioned who your state representative is, I would be quite cautious about that in the future. I think we've got enough end arounds run that you're going to be okay today.
I appreciate that.
But in the future, I would give you caution on that. Judge Ayers, in the brief time that we've been able to spend together, in the few moments right now, I want to thank you for your willingness to serve. That is something that is lost on several folks, that there's many folks that could do this position, but you're not only qualified but also willing to serve. And I thank you for that willingness. As a proud girl dad, as my colleague to the left, to my left just mentioned, you do become a role model immediately. You do become a role model for our daughters and the women across the state. So that is very meaningful and very powerful for me. We talked about our children. My daughter's 20 at UT. I've got a younger daughter I didn't mention who's 10 years old, who thinks she should be at UT right now. And you certainly have influence over the young women in our state, and they will look to you. And I know that you will accept that with honor and with the grace that you have in the last few moments. So thank you, Mr. Chair. Thank you.
Thank you.
Thank you, Chairman Hawk. Next on my list, I have Representative Beck. You recognize, sir?
Thank you, Mr. Chairman, and thank you for being here today, Judge. Just wanted to say, first of all, I've had several cases on my civil side with Batson Nolan, always professional, always collegiate, very fine firm that you come from, number one. Number two is, I think I'm the only Belmont graduate on this platform.
I noticed
so I want to tell you guys, thank you for all that you do for our school. And we wish you luck in this endeavor. Thank you.
so much.
Thank you, Representative Beck. Next, I have Chairman Moody. You're recognized.
Thank you, Mr. Chairman, and thank you, Judge. The thing that impresses me most is that you are a mother of 4 boys. So I'm just saying, anyone that can handle that has got my respect. I'm a mother of 4 also, but not 4 boys. But it means a lot. And as Chairman Hawk was saying, you know, the role model that you already are and will become is very good for our state and for the people here. And I just commend you and want to congratulate you. And I'm taking a step forward that it's going to go through. But I do. It means a lot. And I'm serious, you know, as not that people can if they're not able to be a mom, but being a mom is a high calling and great experience. And so I'm grateful that you're willing to serve, and your husband is backing you too. So I thank you all for what you're doing for this state. Thank you.
Thank you, Chairman Moody. Next on my list, I have Chairman Farmer. You're recognized.
Thank you, Mr. Chairman, and I appreciate you being here today, ma'am. Enjoyed our conversation we had in my office. I just wanted to remind the members on this committee that, you know, what we do based off what you're about to do, you know, our jobs are very subjective, and our jobs here in the state legislature are very district-oriented, whether it be from East Tennessee to Middle to West. And our opinions and our views probably are very political at times. And I think that based off what my colleague had said from Memphis, I wanted the members to understand what your role was and at least how I understand it. Once a case has been heard at the trial court level, that's where testimony is heard. That's where evidence is placed into the record. And the record's key here, because that's the only thing that comes up from the trial court is on the record. What's been objected to, what's been admitted to evidence, what's been testified to. So by the time a case reaches the appellate court level, judges there will hear only what's in the technical record. So that means that there will be no testimony from defendants. There'll be no testimony heard in the Court of Criminal Appeals that wasn't testified to in the trial courts. So I think that's important to understand, and that I am confident that you will interpret the laws that we send your way and that this body has been sending your way for years objectively. So I want to thank you for being here.
Thank you.
Thank you, Chairman Farmer. Next on my list, I have Chairman Halsey. You recognize, sir.
Thank you, Mr. Chairman, and thank you, Judge. On the question of interpretation, do you hold to original intent when it comes to constitutional issues, or do you believe those documents are fluid and living?
Certainly original intent. As I think it was mentioned, I had my Senate confirmation hearing last week, and one of my favorite things that Justice Scalia said is that the Constitution's not living, it is enduring.
Thank you, Chairman Halsey. Members, we have no one else on our list. I just want to echo some of the things that have been said, but I know I'm the youngest of 3 boys, and I know the harassment we gave to our mother growing up, so I'm sure this will be no challenge for you whatsoever, given the environment that you've come out of and overcome. So, but thank you for coming down to the legislature today, and I know this can be a very awkward process, and we realize and appreciate that. But thank you for the way you've handled yourself. Thank you for being an excellent candidate, because it does make our job very easy to be able to field excellent candidates. And so we appreciate your time with us today. And thank you for rearranging your schedule to be here as well.
No problem. I appreciate y'all's time. Thank
Absolutely.
you so much.
Members, we're going to go back into session. And at this time, I would entertain a motion either for confirmation or for rejection of the nominee. We have a motion that's been properly seconded. Any discussion on that motion? Seeing none, we're ready to vote. All those in favor of confirmation, please signify by saying aye. Aye. Those opposed? Thank you, ma'am, for being here today. Thank you, committee. We're finished with that part of our hearing, so thank you very much. Yeah, we're not adjourned. We have a lot more to do. Yeah.
Y'all would like to leave.
Yeah, that's right. Yeah, we would love to go, but yeah. Thank you very much for being here. Members, that does bring us to our regular calendar, which begins with House Bill 1339, which I am carrying on behalf of Representative Ogles, so I will pass the gavel down to our Vice Chair.
Thank you, Chairman Curcio. That is House Bill 1339. Second, I have a motion and a second on the bill. Chairman Curcio, you are recognized.
Thank you, Mr. Chairman. I do wish to move amendment coded 5166, and that amendment makes the bill.
Having a motion and a second on the amendment, would you explain the amendment?
Yes, sir, absolutely. Thank you very much. Members, this amendment does, as I said, rewrites the bill, and it would allow the court to permit remote testimony by a forensic analyst in any criminal proceeding, but only if the state has provided a copy of any report produced by the forensic analyst that the state is seeking to admit into evidence through remote testimony at least 15 days prior to the proceeding. The defendant agrees to permit remote testimony. The court finds that the defendant's agreement was knowing and voluntary. And finally, the court and the state agree to permit remote testimony. Any testimony must allow all parties to observe the demeanor of the analyst as they testify in a similar manner as if they were in the location where the hearing was being conducted. So everyone involved in this process would have to agree to it. Be happy to answer any questions.
Okay, we've got, I think first is Chairman Dixie, go ahead. Representative Dixie.
Chairman Kershaw, this is a very complex situation here. Because can you tell me, like, what is this bill addressing? Like, what instance would this be applicable?
Sure. Thank
Chairman
you,
Curcio.
Thank you. So one of the notes that I have here is that over the last year, it's been common practice to keep the number of individuals in a court proceeding down, due to COVID-19. So obviously, overcrowding in a courtroom. But as we come out of COVID-19, I think that would be less of a concern. But oftentimes, a forensic analyst can spend hours sitting in a court proceeding before they're called to testify. They're there for just kind of one specific piece of the pie, so to speak. And so by allowing them to testify remotely, they'd be able to spend as much time as they need in the proceeding, but then move on to other evidence in our TBI crime lab. So not tie up that resource sitting in a courtroom all day as well, I think helps with that.
Leader Dixie, any follow-up?
No, thank you.
Next on the list is Chairman Halsey.
Thank you. And to the sponsor, that was kind of my question, was this generated by COVID, but this is ongoing. There's no expiration date on this.
Chairman Curcio.
Yes, sir, that's correct. And I think it does have an immediate impact with our kind of lingering COVID situation. But again, with these resources being very dear, especially TBI Crime Lab, they could be doing other things. So I think it does have a purpose even outside of COVID as well.
Any other questions? Representative Hardaway, you are recognized.
Thank you, Mr. Chair. To the sponsor, you referenced TBI. Is this only for the state experts, or would it also apply to private experts?
Chairman Curcio.
Thank you, Mr. Chairman, and thank you for the question. No, I didn't. I apologize. Yes, it is limited to TBI. Thank you.
Thank you. Thank you, Mr. Chairman.
Any other questions? Yes, Leader Lambert.
And Mr. Chairman, I apologize. I should have known that you were going to be running this bill. I was going to reach out to the original sponsor. I know he's unavailable. The last question is what I was trying to get an answer to, and I heard you say earlier that, and I think the language says, both the state, the defendant, and the court all have to concur, and that's correct, right?
Chairman Curcio.
Yes, sir, that is correct.
Yes.
And then I just heard you say that it is only limited to TBI, and I was curious about that because in a lot of instances in court, you may have the TBI have an expert that this would potentially be helpful for, but you may also have a competing expert that could potentially be from out of state that could be helpful in the case. And I didn't know if this covers that or not. And again, I was going to ask the original sponsor of this, should have known he would not have been here today, but are those other entities covered? And if not, why not? Because again, a lot of times there are labs from out of state that this potentially could be helpful with.
Chairman Curcio.
Thank you, Mr. Chairman, and no, thank you for that question. And as you mentioned, I am carrying this on behalf of another member, so I want to make sure I get the answer correct. So if I look in Section 1, we define forensic analyst to say it means any expert in the scientific detection of crime within the Forensic Services Division of the Tennessee Bureau of Investigation or within a regional crime laboratory under the supervision of the director of the Bureau. So I think I read that to mean it will only include our folks in this state and not necessarily the out-of-state folks.
Leader Lambert.
I mean, I don't know whether the intent was to just cover TBI and the other could be covered in another area, but it was when I was reading through this amendment, it's just kind of the first thing that came to mind is there's a lot of expense in getting an expert, kind of an outside expert to come into the state. Quite frankly, in indigent cases, it can get extraordinarily expensive for the state of Tennessee to have experts come in. And if everyone agreed, just as they would for potentially TBI expert, that, hey, look, this could happen remotely, it potentially, and again, I would only be interested in that. Do you know if the sponsor wants to limit this just as it is right now, or are they open to changes?
Chairman Curcio.
Thank you, Mr. Chairman. Excellent question. So I'll answer the second one first. I don't know if the original sponsor is open to changes, but I can't imagine there would be objection to it, but I do know that one of his original intents was to try to speed up TBI's turnaround time on some of these things, so, on other work that they're doing in that crime lab. I think he's also had a bill on rape kits and expediting that process and so forth. So I think he was targeting that turnaround time, but I don't see anything in here that would lead me to believe that we would want to exclude out-of-state members, but I certainly can't speak for the original sponsor of the bill.
Leader Lambert.
And nothing further at this time.
Any other questions? Representative Hardaway.
Thank you, Mr. Chairman. And Leader Lambert just brought the question to mind for me. Is this only for the prosecution, or does it also apply to defense experts?
Chairman Curcio.
Thank you, Mr. Chairman. I apologize. Could you restate the question?
Following up with Leader Lambert's line of questioning, is it merely for the prosecution, or would the defense also have the ability to bring in their analysts virtually or digitally?
Chairman Curcio.
Thank you, Mr. Chairman. So if the forensic analyst meets the definition in the bill, then they would be able to testify remotely as long as everybody agreed to it. But they would have to meet that definition. So in this case, the defense would have to be using someone who works for the Forensic Services Division of the TBI or within a regional crime laboratory under the supervision of the director of the Bureau. But it doesn't speak to whether it has to be the prosecution or the defense.
Representative Hardaway.
Yes, sir. I've gone from hot on the bill to lukewarm on whether it fills a void or whether it tips the scales. So I'm not sure where I am now on the bill, Chairman Curcio. Thank you.
Leader Lambert, you're recognized.
Thank you, Mr. Vice Chairman. And Mr. Chairman, if I may make a suggestion, if we could roll this a week to consult with the original sponsor, I think it potentially would be a good idea to just open it up to all entities. I thought about this as the debate was going on farther. There are also outside labs that the state uses from time to time. So it's not even just the defense. I mean, there are some times in order to get caught up or to utilize outside labs, I mean, sometimes there's just other labs that are used. So it might be beneficial to maybe open this up a little bit, especially if everyone has to agree and no one's being forced into this. With some small changes, it might even turn the heat back up on Representative Hardaway. You never know. So.
Yes, sir. Thank you, Mr. Chairman. And I'm completely amenable to that. We have received word from the original sponsor's office that he would be open to some changes. So I have absolutely zero objection with that. And Mr. Chairman, if I may, I would make a motion to roll this bill 1 week.
Okay, I have a motion and a second to roll this bill 1 week. Everyone in favor say aye. Aye. Opposers, no. Bill has been rolled 1 week. That is House Bill 1339. And I will be passing the gavel to Chairman Curcio.
Thank you, Mr. Vice Chairman. Appreciate you taking the gavel there for a moment. Members, we are going to jump to item number, I believe it's 12. Nope. 5? Sorry, item number 5 by Chairman Ramsey. Sir, thank you for being patient with us today. Sir, you have a motion and a second. You are properly recognized before the committee.
And thank you, Mr. Chairman. It's always a thrill to find out what real judicial processes are. Always enjoy it here. This bill, we won't get into amendments today. This bill, I am planning to take off notice, but I did want to say a few words about it first, if it's okay with the committee. This bill is really about a family and close to my district. All of you remember Doug Gunnels, the Department of Transportation liaison that has worked with us so long. His son, Corey Gunnels, would have been seeing his 44th birthday next year. The story we have here is a man with a wife, 2 children, a father, we know Doug, and just a random accident in a CT scan had detected neuroendocrine carcinoma, which has a 5-year survival rate of 50%, which is very, very threatening. The long story of many treatments of up and down, retraction of the tumors, and then regrowth, extremities, pain, and situations that essentially had lasted him for 10 years. He was 33 when he first diagnosed, and so about 6 months before his passing away, he had found a friend of a friend that had suggested some high content oil from the cannabis products that had given him some relief. And the issue is resolution in situations like this when medical care had failed and the consequences of his care were actually more devastating than the disease. We know that in situations like this, resolution doesn't mean a cure. It means a better lifestyle. And so I brought this bill up. We passed it through Health Sub, Health Full, and brought it here with the hopes that that we would be able to at least tell his story. And what happened with him, he passed away while we were actually presenting the bill 2 weeks ago in Health Full. The last 6 months of his life, essentially we had forced him to enter into a black market world of medical cannabis, which does exist in the surrounding states here. And our greatest fear is that Tennessee will be the last state to adopt legal possession of medical use of cannabis, of oral or topical products. So with that explanation, and I came to the chairman here, and with his typical judicial candor, he told me, "Bob, your bill's dead." But and I understand that. It's a very difficult issue. It's an issue that we need to address. We're going to have to face it. Our constituents, 70 to 80% of it, are demanding that we face it. So with that, sir, and pending any questions, I will ask that this bill be taken off notice with the preparation that we'll address it again next year.
Representative Griffey, you seek to be recognized.
Yes, Mr. Chairman, thank you. Thank you for bringing this bill. While I don't support it, you know, we live in a constitutional republic. You know, we are elected to come up here and make the laws for our citizens, but our citizens have the right to pass on measures by constitutional amendment or ballot measures, and maybe this is one of those issues that the citizens all decide for Tennessee, whether regarding marijuana and recreational marijuana, medical marijuana, whatever. I feel like that would give everybody up here comfort what the citizens want, and we would be doing what the citizens want. Thank you very much. Appreciate you bringing the bill.
Thank you, Representative Griffey. Yes, sir.
Chairman Russell?
Yes, Chairman Russell, you're recognized. I was trying to think, I was like, Chairman, not Chairman. Yeah, Chairman Russell, you're recognized.
That's pretty close, though. That's, anyways, thank you, Chairman, and thank you, Chairman, for bringing this up to us. And, of course, I know the whole Gunnels family, and I hope everybody keeps them in their prayers, and hope we can revisit this next year. Thank you.
Thank you, Vice Chairman Russell. Any other questions for Representative Hardaway, you recognized?
Thank you, Mr. Chairman. My sympathies to you and the family for your loss, Chairman Ramsey. The surrounding states, those contiguous states of for Tennessee, how many of those are either legal or working their way towards it for this medical marijuana?
Chairman Ramsey.
Mr. Chairman, and I can tell you there are, I think, a total of 38 states now that either have recreational or medical cannabis approval. That as far as the ones that border Tennessee, I think maybe half of them do have that capacity. But that's one of the big issues we have. Law enforcement comes to us and says we really don't know how to treat this. We don't know exactly what the other states' regulations are. And part of this bill, the amendment that made the bill, came from the Tennessee Medical Association. And so one of their requirements was that it be purchased legally in another state. And of course, that's a confusing issue for law enforcement. But I think it's easy enough. I mean, we have 30 plus other states that have managed to face this issue and face it successfully. And I might say that a lot of people ask me, where do the black market folks get these products from legal states? And I got to say, it's rather easy, and it's done through the mail.
Representative Hardaway.
And the quality of the medication, the consistency of the medication, if you're doing it black market, different states could have different criteria.
Chairman Ramsey.
And if indeed the product is purchased in a state that has legalized medical cannabis or recreational, those states are very judicious and particular in having quality control. I've actually gone to another state, Nevada, and they have actually legislative programs where they take you through their processing and growth and the parts of the industry. And let me say that they are very judicious about quality control.
Representative Hardaway.
And those states are satisfied with the results, and they're not trying to reverse anything.
Chairman Ramsey.
And I don't know any that have tried to reconsider the use of medical cannabis or recreational.
Thank you, Mr. Chairman. Thank you for the bill. Looking forward to supporting and working with you.
Next on my list, I have Representative Lamar. You're recognized.
Thank you, Mr. Chairman. Thank you, Chairman, for bringing this bill. I think this is a very good bill. I do agree with you that we must face this issue. The MORE Act has passed in the United States House and is expected to pass the U.S. Senate and is going to head to the President's desk, where we'll be addressing this issue nationwide. And I kind of find it hard to believe that Arkansas and Mississippi are facing this issue before we are. I don't never want to be behind Arkansas and Mississippi. But my question is, is marijuana found to be more effective at curing PTSD and other medical issues more effectively than prescription drugs and opiates?
Chairman Ramsey, before you answer that, I just want to remind everybody that we are on a bill that has been general subbed in the Senate, and as the sponsor has requested to take it off notice. So to the extent we have questions for the sponsor, I just want to make sure we stay within the parameters that this bill would have addressed. So, Chairman Ramsey, you're recognized.
Yes, there are probably 200 to 300 chemicals in the cannabis oil, whereas there's one synthesized chemical in the pain medications, Marinol, and the substitutes for the THC. As far as opioids, we all know the terrible side effects of opioids. We have so many deaths per day from opioid overdose, and it's hard to find anybody in history that's ever overdosed with cannabis product.
Representative Lamar.
Thank you. And I just asked that question because it's a subject matter of healthcare, and it did go through the health committee, so it's dealing with health. But I appreciate you bringing this bill and challenging us to go ahead and face this issue. That's an issue that we're going to have to face anyway. So I look forward to supporting your bill next time.
Thank you, Representative Lamar. Next on my list, I have Leader Lamberth. I'm sorry, Chairman Ramsey, did you want to respond? Okay, Leader Lamberth, you're recognized.
Thank you, Mr. Chairman. Chairman, thank you for bringing the piece of legislation. I know why you brought it. It was an extraordinarily limited piece of legislation that dealt with just one particular product. I know we've gone quite far afield of that, and I'll also look forward to the debate on my constituents being able to actually have this discussion with their doctor instead of the fellow at the 7-Eleven that's trying to sell them whatever substance he feels like right now, that many of these states have legalized and said, sure, get your medical care from the local convenience store. I would prefer they actually go to their doctor and get the care that they need. So if we're going to have this conversation and we're going to have this particular argument, I would prefer that this Love Fest have both sides of the argument that's well beyond this particular bill. And that's all I'm going to say for today's purposes.
Thank you, Leader Lamberth. Next on my list, I have Representative Beck. You're recognized, sir.
Thank you, Mr. Chairman. I just want to thank Chairman Ramsey for bringing this bill. And it just saddens me that we as a state are still depriving these people who could benefit so much from this therapy, and that we're keeping them from that. The polls have shown that it's in the 80 to 90% approval rate, and I hope that we can follow what Leader Lambert said, and that we can work toward making it able for people to talk to their doctors and get this relief. And I thank you again.
Thank you, Representative Beck. Next on my list, I have Chairman Holsey. You're recognized, sir.
I move to take the bill off notice.
We have a motion and a second. Without objection, the bill is off notice.
And Mr. Chairman, thank you for your compassion and your indulgence, and thank you for leaving these glasses for me, because you knew
those,
I was old.
Those are the committee glasses. Yes, sir. Thank you for not stealing them. We appreciate that. Members, we're going to jump to item number 12 and then number 13 by Chairman Baum. Chairman Baum, we appreciate you being patient with us. I know you waited several hours a week or so ago and wanted to get to you as quickly as we could. So item number 12, House Bill 1211. Sir, you have a motion and a second, properly recognized.
Thank you, Chairman Curcio. More and more folks are buying their merchandise online. This is particularly true in the pandemic, and they don't like it when their packages are stolen off their front porch. This is a bill that's designed to increase the penalties on stealing packages that have been sent through the mail. It doesn't do it on a first offense. On the first offense, the penalty is still charged based on the value of the package. But on the second offense, the minimum penalty would be as a Class E felony. It would still be determined by the value of what's been stolen, but in that scale, the punishment couldn't be any less than a Class E felony. A third of all Americans are reporting having had packages stolen, and so this is a way to address that problem.
Members, you've heard the explanation of the bill. Any questions for the sponsor? Question's been called. Seeing no objection, all those in favor of sending House Bill 1211 to Finance, please signify by saying aye. Those opposed? Sir, you head to Finance.
Thank you all.
Yes, sir. That brings us to item number 13, also by Vice Chairman Baum, House Bill 1334. Sir, you have a motion and a second, properly recognized. And I see an amendment. Do you wish to move that amendment?
Yes, I do.
Sir, we have a motion and a second, but I want to make sure for the record, is amendment coded 4678, is that correct?
Correct.
All right, it appears as though the amendment writes the bill, so please explain your amendment.
Thank you, Chairman Curcio. The Tennessee General Assembly has done a lot to increase awareness about the problems associated with human trafficking and sex trafficking over a number of years, and we've done a lot in order to prevent these activities. Much of our work has been in schools by training teachers and providing information for students, like in the high school lifetime wellness course. This is a bill that would allow us to work in a slightly different area. It would require the 19-member Tennessee Human Trafficking Advisory Council to develop an awareness poster on human trafficking and sex trafficking. The posters would be hung in Tennessee's welcome centers. Tennessee has 16 of these welcome centers off the interstates. The posters could include information about our TBI hotline phone number, as well as our web page that provides information about human trafficking. The bill suggests that this committee consider placing these posters on the backs of bathroom door stalls where travelers might have a moment of privacy and they could take down the number or the web page or even make a phone call at that time. This approach is exactly what some high school seniors in Rutherford County have done at high schools, posting these kinds of public awareness posters on the backs of high school and middle school bathroom stalls.
Members, you've heard the explanation of the amendment. Any questions for the sponsor? Okay, seeing none, all those in favor of attaching amendment coded 4678 to House Bill 1334, please signify by saying aye. Those opposed, you adopt. We're now on the bill as amended. The amendment made the bill. Any further questions? Representative Hawk, you're recognized.
Thank you, Chairman. Thank you, Indulgence Committee. Just a quick comment. The availability and distribution of these posters, I think, is critically important, and to go beyond the welcome centers, to go beyond the areas that we're talking about. So I think that's, as we have this discussion, as the design is accomplished from the Advisory Council, I think we need to have a bigger conversation about numbers and broad distribution. This is certainly a good beginning to the conversation, but we need to talk about larger numbers and where they go. So thank you, Mr. Chairman, members.
Thank you, Chairman Hawk. Seeing no further questions for the sponsor, we're ready to vote. All those in favor of sending House Bill 1334 as amended to calendar and rules, please signify by saying aye. Those opposed? Sir, you had to calendar and rules.
Thank you all very much.
Thank you very much, sir. Appreciate your patience. Members, that's going to bring us back to item number 2, which is by our own Leader Lamberth, House Bill 1599.
Motion.
Sir, you have a motion and a second. Properly recognized.
Thank you, Mr. Chairman. I'm running this for Chairman Carter, who obviously due to health issues is unable to be here today, and it does exactly as presented.
Members, you've heard the explanation and been able to read the caption spread on your desk. Any questions for the sponsor? Hearing none, I will entertain a vote. All those in favor of sending House Bill 1599 to Finance, please signify by saying aye.
Aye.
Those opposed? Sir, you head to Finance.
Thank you, Mr. Chairman, and members of the committee.
Thank you, sir. That brings us to item number 3, House Bill 1171 by Chairman Terry. Sir, you have a motion and a second. You are properly recognized.
Thank you, Chairman and Committee, and there's an amendment 6655.
Sir, you have a motion and a second on your amendment. Please explain the amendment, sir.
Right. Thank you. While the United States does not have a federal firearms registry, nor is there a plan for confiscation right now, there certainly is discussion about the issue, including a bill that was filed March 1st of this year entitled the Firearms Licensing and Registration Act. In 2015, we passed Public Chapter 380 on anti-commandeering doctrine that says that the state or any local subdivision will not use funds, personnel, or property to enforce any federal law that is against Tennessee state law or constitution. The bill has, the amendment here has two main goals in the event that the feds try to infringe on the Second Amendment rights via confiscation or registration. First, it puts teeth in Public Chapter 380 by adding a Class A misdemeanor to a state or political subdivision personnel that discloses firearm information for the purpose of confiscation or registration. And second, it grants a cause of action for a firearms owner against an individual who would disclose their firearm information for the purposes of registration or confiscation. The bill does have some exclusions for criminal investigation or if required by an FFL.
Thank you, Chairman Terry. First on my list, I have Leader Lamberth. You're recognized.
Thank you, Mr. Thank you, Mr. Chairman. The only thing wrong with this bill is I wish I'd thought of it first. This is literally one of the best bills I've seen all year. This deals with private information that is none of anybody else's business. One of the first bills I filed when Chairman Farmer and Moody and others were elected that year was a bill to prevent a public list of your handgun carry permit recipients. And for those that were here that year, we supported that and made sure that you couldn't get a list of folks that had a carry permit. What that was a shopping list for burglars. And there was a newspaper in a city in this state that was literally putting that online, and anybody out there that wanted to know exactly which homes had guns and which ones did not could go on a publicly accessible database. That is simply none of anybody else's business, whether you own a firearm or not. It's a Second Amendment right to possess that firearm, and none of this information should ever be public. So thank you. I know with your medical background, this appears to really mirror the HIPAA statutes that protect medical records. This is absolutely a constitutional right that we should preserve, and in protecting this private information, it protects folks from having that information out there to be utilized not only potentially for gun confiscation, but for other nefarious means. It's simply private information that's none of anybody else's business. So thank you for bringing the bill, and not only do I hope folks support it, I hope folks on both sides of the aisle would protect privacy and maybe even sign on to this bill. Thank you.
Thank you, Leader Lamberth. Any response, Chairman Terry?
Just thank you for the comments.
Next on my list, I have Representative Hardaway. You recognize, sir.
Thank you, Mr. Chairman, and good afternoon to the sponsor. I want to make sure I'm understanding this correctly. If there's federal law that conflicts with this statute, if it's passed, then this statute would criminalize, or would it put civil penalties in place for following the federal law?
Chairman Terry.
Thank you. If that federal, the Firearm Licensing and Registration Act becomes law, which as it's written, you have 3 months, if it passes, you have 3 months to turn in all your firearm information to the feds. If that becomes law and you are a personnel of this state and you give that information, yes, it would be a Class A misdemeanor. If you are an individual and you give that to them for the purpose of registration, then yes, that would create a cause of action.
Representative Hardaway.
Thank you, Mr. Chairman. Can we create legislation that overrides federal law?
Chairman Terry.
You could ask legal services to answer that question, but this says that they will not give that information to them, and anti-commandeering doctrine says that our personnel will not, which we've already passed, Public Chapter 380 says that our personnel will not, or our funds will not be used, so I would say that we have done that previously.
Representative Hardaway.
All right, so if there's federal prosecution for lack of cooperation, will the state pick up that legal bill, or will the AG represent whomever it is that's following state law that conflicts with federal law?
Chairman Terry, you recognize.
Thank you. I'm not sure I understand your question. This says that if personnel of the state gives that information, and there are exclusions in here, whether it's for post-commission or for an FFL, so there are exclusions in here, but this says that it would be a misdemeanor for that personnel to give that information to the feds.
Representative Hardaway.
All right, I'll try to be a little clearer. If the feds find, if they prosecute for lack of cooperation because their law conflicts with this statute, if it passes, who would pick up the legal bills for a Tennessee official who cooperates with the feds, who cooperates rather with the state? Wouldn't they be subject to federal prosecution, and would the state cover the legal costs for the state official who is following state statute and getting in trouble with the feds for not following federal statute?
Chairman Terry.
If that conflict would happen.
Thank you. That may be a question for legal services to answer. I'm not sure I quite understand what you're getting at. I would submit, though, that in this bill, there is a, if I can find it here, on the civil portion of that where it says federal law, the reason that I have that in there as an exclusion on the civil portion of that has to do with FFLs, in the fact that if there is a gun dealer and it becomes federal law for them to have to report that, it would exclude them. I would submit that if it becomes federal law to essentially whistleblow on your neighbor's Second Amendment rights and give them up, we've got a bigger problem.
Thank you, Mr. Chairman.
Thank you, Representative Hardaway. Next on my list, I have Chairman Hawk. You recognize, sir.
Thank you, Mr. Chairman. No question. I just want to make sure we're walking off the correct amendment. Can we restate that amendment? My hearing may be off, the tracking code number on that.
6655.
And that is what I have as well, 6655.
Okay. Thank you, Mr. Chairman. Thank you for clarification.
Any further questions for the sponsor of the amendment? Seeing none, we're ready to vote. All those in favor of attaching amendment coded 6655 to House Bill 1171, please signify by saying aye. Aye. Those opposed? No. The ayes have it. You adopt. The amendment made the bill. Any further questions for the sponsor? Seeing none, all those in favor of sending House Bill 1171 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? No. The ayes have it. Sir, you head to calendar and rules.
Thank you, Chairman and Committee.
Thank you, sir. Next up, we have also by Chairman Terry, House Bill 1312. Sir, you have a motion and a second.
Thank you. There's an amendment, 4243, I believe.
Sir, you have a motion and a second on amendment coded 4243. It does appear to rewrite the bill, so you're recognized for explanation.
Thank you, Chairman and Committee. This issue was brought to me by a constituent and is truly a concept in self-governance. There was a mother whose daughter rolled her vehicle in a fatal car accident one evening. Pictures were taken at the scene. The mother became aware of the pictures and inquired about their potential use, including for training purposes. And she realized that as a parent and as a victim, she did not have parental rights to keep those graphic photos of her daughter confidential. The goal of this legislation is, as amended, is to safeguard the privacy of deceased minors. All photographic evidence of a fatal motor vehicle accident that depicts a deceased minor victim at the scene of the accident to be treated as confidential. It's not open to public inspection, and if a custodial parent or legal guardian wishes, they are authorized to waive this confidentiality. And it also does not restrict the application of Rule 16 of the Tennessee Rules of Criminal Procedure.
Representative Griffey, you're recognized.
Thank you, Mr. Chairman. Thank you for bringing this bill, and I fully support it. I did have one question. We're talking about photographs taken by state officials,
Chairman Terry.
as opposed to private individuals that
Yes.
come up on the scene. Thank you. That's all I had. Thank you.
Okay. Members, any other questions for the sponsor of the amendment? Chairman Hawk, you're recognized.
Thank you. Forgive me for being so chatty. I'm wondering about the description does talk about motor vehicle accidents. I know the most recent incident in California where we lost Kobe Bryant, there were photographs of his helicopter crash. I'm wondering if future times we can include other incidents in this particular legislation, because I know that California had to address that particular issue. Would this fall in line with this piece of legislation, Chairman Terry?
Chairman Terry, you're recognized.
Thank you. This says motor vehicle accident, but I think it's in the similar vein, and I think that sounds like either a good bill or good amendment.
Chairman Hawk.
Thank you. And I see where it has been passed it's been sent over, it's passed the Senate and been sent over to us. So I don't want to stop progress on that, but just for your consideration, if we could find some wording, if you'd entertain that amendment this year or future years. I'm not going to stop the progress, but just that consideration going forward, that may be something that this House could entertain and send to the Senate at some point in time. Thank you, Chairman.
Thank you.
Thank you, Representative Hawk. Next on my list, I have Chairman Holsey. You recognize, sir.
Okay, you might have addressed this. Thank you, Chairman. in the police department, we have 40-hour in services every year, retraining. You have accident investigation classes that go on. Did you say that those classes were exempt from this, or they cannot use these photographs even in training in that type of setting?
Chairman Terry?
Thank you. And that was the concern of this parent that brought this legislation, is that these photographs would have been used, could potentially have been used. They were not, but they could have potentially been used in a training purpose without the mother's consent. And so that's what they're trying to get at with this, is that if you're going to use very graphic photos of a child, of a minor, that you at least have the parent's consent for that. And to that point, I think she would have consented, but she just wanted to make sure that she has that consent and those rights.
Chairman Halsey? Okay, thank you, sir. Any further questions for the sponsor of the amendment? Seeing none, we're ready to vote. All those in favor of attaching amendment coded 4243 to House Bill 1312, please signify by saying aye. Those opposed, you adopt. Members were on the bill as amended. The amendment did make the bill. Seeing no further questions, all those in favor of sending House Bill 1312 as amended to calendar and rules, please signify by saying aye. Those opposed? Sir, you had to calendar and rules.
Thank you, Chairman and Committee.
Thank you. Members, I don't mean to give myself any special placement, but I do have a bill at the end of the calendar. We are running short on time today. I'm going to pass the gavel down to our vice chairman because we do have someone here to testify on that bill, and they traveled some distance, and I don't want them to go away without being able to testify. So, well, I'll go ahead and move the bill, and then, yeah. We're going to item 24.
Thank you, Chairman Curcio. We are on item 24, House Bill 1416. Need a motion and a second.
Motion.
You've got a proper motion and a second. Chairman Curcio, you are recognized.
Thank you, Mr. Chairman, and thank you, committee. Members, House Bill 1416 creates the Class A felony of aggravated human trafficking. Tennessee consistently ranks either number one or near the top of the pack as having the best human trafficking laws in the country, but House Bill 1416 continues in our efforts to keep victims safe and punish criminals to the fullest extent of the law. This bill will make three substantial changes to the way our human trafficking penalties currently function. First, the amendment will punish the trafficking of any minor for a commercial sex act, not just a child under the age of 15, as a Class A felony. Second, the amendment will require that anyone committing a human trafficking offense to serve at least 85% of their sentence before release. And third, the amendment will create the new offense of aggravated human trafficking. Anyone who commits a human trafficking offense against a child under the age of 13 will have no release eligibility until they serve 100% of the sentence imposed and will automatically qualify for a sentence range enhancement. With that, Mr. Chairman, I would be happy to take any questions, but as I mentioned, with your indulgence, we do have someone on the list to testify, and I know they'd like to be heard today.
Thank you, Chairman Curcio. One moment, please. Okay, without objection, we're going to go out of session and hear our testimony. So we are out of session, and we have Ilonka Deaton. And if you would, just state your name correctly and your position, please.
Thank you, Mr. Chairman and members of the committee. It is Ilonka Deaton. Thank you so much for allowing me to be in front of you today. I'm deeply honored and with a grateful heart. My name is Ilonka Deaton. I am a mom of two and a third one on the way. I live in Franklin, and I've been a member of our beautiful Tennessee for about 20 years. For 5 years of my life, from age 12 to 17, I was unfortunately sex trafficked. I walked into my adult life with severe trauma, and it took me almost 7 years before I had the courage to speak up for the first time, to say I want to press charges against the man who did this horrific crime to me and sold me multiple times to other men. My husband, who's very brave, found this man, tracked him down back in South Africa. We went and we filed charges. However, in 2012, there weren't any sex trafficking laws on the books to be able to do this. We're borrowing from the penal code. So my case could not go anywhere, right? Now I'm a mom. I'm a concerned citizen of Tennessee. And I do not want what happened in South Africa or what has happened in other states in our country to happen here. I want my children to be protected. I want to make a deep statement that do not come to Tennessee and traffic our children or our grandchildren or my neighbors' kids. I think this bill is extremely important. I urge you to vote to pass this today because I've lived it. I am fortunately part of the 1% of survivors who have gone on to have a family and a normal life because I've had the family support. But for more than 80% of victims, that is not the case. So I want to be their voice today. And I urge you to vote on this bill. And thank you so much, Mr. Chairman and committee members, for your time today.
Thank you for your testimony. And may I just say that it's never easy to do what you're doing, what you have done, but it's commended that you have the strength and support to do this, because I believe that it does bring awareness to the situation that this happens, and I don't think it's got the attention that it's needed. So it's something very brave on your part, and I want to commend you for doing that. So do we have any questions? Chairman Curcio, you're recognized.
Thank you, Mr. Chairman, and I just want to echo that. I want to say thank you so much for being here. I know you you sought me out after this bill had been put on notice and was moving through the process. So thank you very much for taking time out of your life and out of your day to come down here and advocate on an issue that obviously you're very passionate about and unfortunately know too much about. And so I just want to thank you very much, and I wish more Tennesseans would be more involved in the legislative process and come down here and speak their mind. So thank you so much for what you've shared with us today.
Thank you, sir.
Anyone else like to speak? If not, I'm going to ask you to give a round of applause for this brave lady. That'll be all. Thank you.
Thank you.
Okay, if there's nothing else, we're going to go back into session. We're back on House Bill 1416. Any questions for Chairman Curcio? Representative Chairman Halsey, I'm sorry.
Thank you. I just had one question. This Class A 100% felony applies when the victim is under 18. Is that correct? This wouldn't apply to a 40-year-old working in a house in Knoxville that's run by a madam.
Chairman Curcio.
Yes, sir, that is correct. It's any minor for a commercial sex act, not just a child who's under the age of 15. Be the Class A felony.
Okay, thank you.
Yes, sir.
Any other questions? Representative Hardaway, you're recognized.
Thank you, Mr. Chairman. To the sponsor, what the prosecution under this bill, when it passes, would that be for the date of the deed or the date of the prosecution? How would that work? How
Chairman,
retro can this
Chairman
be?
Curcio.
I think I understand the question. This would be for offenses committed on or after July 1st. So these are for new crimes moving forward. Is that the question?
Representative Hardaway.
Yes, sir. Any way to? Well, we'll talk about that later. I just think if someone, and we've seen the evidence that quite often those who are victimized find it difficult to bring the subject matter to the attention of anyone, especially law enforcement. So is there some way, Mr. Sponsor, that we can take that date and apply it to those crimes where the victim first identifies or brings it to the attention of law enforcement?
Chairman Curcio.
Thank you, Mr. Chairman. I think I understood. I understand the spirit of the question you're asking, and I certainly appreciate the spirit in which it's brought. You and I had an exchange once on the House floor about whether or not retroactive bills are constitutional, and so I think, unfortunately, we wouldn't be able to make a bill retroactive. But we're certainly doing what we can, from now moving forward. I will also mention, and this doesn't help the exact issue that you have, but we passed a statute of limitations bill a couple of years ago, which would extend the time at which you could move forward, with a case. Now, again, it doesn't mean that this penalty would apply because it would be for new offenses that occurred on or after the enactment of this legislation. But I certainly understand the spirit of what you're doing, and I don't disagree with you. I just don't think it's possible that we do that.
All right. Thank you, Mr. Chairman. And I didn't get a chance to express my appreciation to the witness, and thank you for your strength and your
Any other
willingness
questions?
to campaign.
Question on the bill? We are on House Bill 1416. All in favor of moving on to finance, let it be known by saying aye.
Aye.
Opposers, no. The bill moves on to finance. Thank you.
Thank you, Mr. Chairman, and thank you, committee members. We do have a few more minutes before 5 o'clock, so I'm going to take us back to item number 6, which is House Bill 1433 by Chairman Holsclaw. Sir, you have a motion and a second.
I feel like I've served my time to be able to present this bill.
Yes, a second. Sir, you have an amendment. I hear a motion and a second. I want to make sure we've got the right code. I have amendment coded 5396. Is that correct?
That is correct, sir.
All right, you have a motion and a second on that. It does make the bill. Please explain.
That is correct. It makes the bill. Basically, what this does is it enhances the penalty to a Class C felony when a person discharges a firearm from a motor vehicle. Currently, it was considered a Class E, and it's moved to a Class C to strengthen that a little bit.
Members, you've heard the explanation of the amendment. Question has been called on the amendment. Without objection, we're ready to vote. All those in favor of attaching amendment coded 5396 to House Bill 1433, please signify by saying aye. Aye. Those opposed, you adopt. Members, we are on the bill as amended. Chairman Holsey, did you have a question? Chairman Holsey, you recognize.
I did. Pointing a gun or shooting a gun at somebody is already a Class C felony. Are you just like shooting out the air, or?
No, this is actually when you're this comes from traffic safety on the highway as far as shooting a gun at another vehicle. It is currently considered Class C, if I'm not mistaken. Is that correct?
Chairman Holsey, you wish to be recognized for a follow-up?
No, that's fine.
Next on the list, I have Leader Lamberth, and we may have another question as well here, but Leader Lamberth, you recognize?
Thank you, Mr. Chairman, and to the member sponsoring the bill, thank you for sponsoring this. There are many situations, both in the rural areas where I live and in some of the more urban areas, where there are, unfortunately, individuals that will grossly misuse their firearm by shooting out of a moving vehicle, sometimes at a sign, sometimes at a house, sometimes just shooting it. And as you know, as an expert marksman, I mean, that is extraordinarily dangerous. And unbeknownst to them, many times they are endangering individuals in the community. They may not be intending to, so it's not the aggravated assault you've described, but every time you fire a bullet, you own the destination of that bullet. And you need to be very, very careful about that. So I think increasing that penalty is a very good idea. No one should engage in that type of activity, because many times they're not checking their background. They're not checking to see whether or not there's anybody in the area. They're not checking to see if there's a berm that's going to stop that bullet from going into someone's house or car or person. It's very, very, very dangerous. So again, I think that's the point of the bill in discussion with the sponsor previously. Thank you, Mr. Chairman.
Thank you, Leader Lamberth. Any further questions for the sponsor? Seeing none, we're ready to vote. All those in favor of sending House Bill 1433 as amended to Finance, please signify by saying aye. Aye. Those opposed? Sir, you head to Finance.
Thank you, Chairman.
Thank you, sir. Next up, we have Chairman Todd, if he's in the room. He is. Okay. Sir, I'm going to recognize you on item number 8 on our calendar, which is House Bill 1388. You have a motion and a second. I also see an amendment. You wish to move forward with that amendment, sir?
Yes, sir. Drafting Code
4096.
I see 4096. It makes the bill. Please explain your amendment.
What this does is it rights what I consider a wrong in our code right now. For many, many years, since the late 1800s, we have had on our books an offense that I believe is taking away liberties from our citizens. As all of you have taken an oath, just like myself, would concur that our defense of liberties is primary in our Constitution, both the state and federal Constitution. One of those liberties is the right to keep and bear arms, which is enumerated in the Second Amendment. Our state, many years ago, infringed on that right by stating that it is an offense to carry a club or a firearm in this state. And we have a permit system that allows you a defense, still an offense, but it allows you a defense only from prosecution. And what we passed a couple of weeks ago that would allow more people to carry without a permit does the same thing. It just offers a defense. So you could still be arrested with a permit. You could and if you met the qualifications that were spelled out in the bill we passed, you could still be arrested and spend a night in jail, have to hire an attorney to defend you, spend money on that if we had some rogue DA that wanted to do that to you, because it is a defense only. So what this bill does, it simply rewrites Section 3917-1307 and says it is no longer an offense unless you meet the qualifications that are already spelled out in 1307 of being a felon, being mentally adjudicated, and so forth. And so those things, as you can see in the bill and the amendment, are all spelled out. So I'll be glad to take questions. That's what the bill does.
Members, you've heard the explanation of the amendment. Any questions for the sponsor? Seeing none, we're ready to vote. All those in favor of attaching amendment coded 4096 to House Bill 1388, please signify by saying aye. Those opposed, you adopt. We're now on the bill as amended. The amendment made the bill. Any further questions? Seeing none, all those in favor of sending House Bill 1388 to Finance, please signify by saying aye. Those opposed? No. Sir, you head to Finance. If you wish to be recorded as a no, please do so with the clerk. Members, it is 5 p.m., and we do have a hard stop at 5 p.m. today. And we will now adjourn. All of the bills that we did not get to will roll to our next available calendar. We're adjourned.